Good afternoon, ladies and gentlemen. Welcome to the webinar on EU conflict of laws for companies. It is a great honor for me to chair this afternoon's session. Let me introduce to you the members of our panel in alphabetical order. Although this is not the order these people will be speaking, we have with us this afternoon Professor Luca Enriquez from the University of Oxford. And you see him on the screen and you immediately see he's from Oxford, from the nice background his university is providing. Now, in alphabetical order, the next person on my list is myself. My name is Georg Kodek. I'm a professor here in Vienna at the University of Business and Economics, and I'm also a judge of the Austrian Supreme Court. So I am a sort of a professional hybrid, as it were. Then we have with us Professor Chris Tumale from the University of Vienna, and we have Professor Jessica Schmidt from the University of Bayreuth. Sorry, she should have come next and Professor Tumale last, so my apologies for this mistake. Now, ladies and gentlemen, my task as a chair of this session is twofold. Number one, and probably foremost, I am to maintain strict time discipline. We are supposed to finish within 1 hour, and that comes to about 10 minutes of presentations for each of us. And then we have a remaining 17 minutes, wherever that figure comes from, for Q&A. Now, my second task is I will try to lay the ground for what comes next, for the subsequent speakers, which are going to present and comment on the feasibility study. Now, I have prepared a short slide presentation, which I'm going to share with you. As you know, obviously, the world is getting smaller. It's getting smaller not because the poles are melting, but because there is more interaction, both commercial and otherwise. And as a consequence, international private law is getting more and more important. Now, traditionally, international private law, certainly in European academia, was more focused on family law, the law of succession, and so forth. Then, in the next stage, people began to look at contracts, began to look at torts, and now we are moving on one step and venturing into more dangerous, more complex territory, uncharted territory almost, if I may use that term, and that is international company law. Now, you see my agenda on the slide. I'm going to start with an actual case. And I have prepared a little map of Europe, not that you would need a map to find Cyprus, but that is where our case started. We have a company in Cyprus which takes out the loan in Germany from a German company. And that Cyprus company runs into financial difficulties, and they were over-indebted by about a billion euros. And as a part of the restructuring, they merged with a company in Austria. Now, that's the red arrow on my slide. Now, the question was, in a case that was decided, or rather put by the Austrian Supreme Court, or more precisely, a case in which the Austrian Supreme Court put a preliminary question to the European Court of Justice. That case involved this transaction I just mentioned. Now, we had two Austrian companies, but we had a loan that was governed under the terms and conditions by German substantive law. And we had a company from Cyprus, so governed by Cyprus law, that merged with a company in Austria, ending up being an Austrian company. So we had possibly the legal systems from three countries which might apply. So this case is my starting point. when we look at the current framework of international private law of companies, we obviously have the Rome regulations, Rome 1, Rome 2, and I realize there are other regulations, but these regulations basically are supposed to fit together, to connect seamlessly, like a jigsaw puzzle. But there is a carve-out, and that carve-out includes a long list of areas of laws which are not governed by these regulations, and unfortunately, one of these areas of carve-outs is corporate law. Now, when it comes to a company's affairs, when we just talk about internal affairs, how a company is set up, when we talk about shareholders' rights, about shareholders' decisions, about the management of a company, that is just indeed an internal affair, which is a term of art. That's not so difficult. We can choose any legal system basically to govern these matters. Now, things get really tricky when there are what I call interfaces, intersections with the outside, with the external world. Like, does the outside world have to recognize that company, that body corporate that was just established? What about the powers of directors? What about, and that I'm sure is a more controversial question, what about capital maintenance requirements, capital preservation requirements, and what about other mandatory rules? And I realize the threshold under the Rome regulations for mandatory rules is quite high. But when we just talk about the carve-out, then the threshold obviously may be a lot lower. Now, on this slide, I have listed some of the factors that may influence the applicable law. Now, clearly, at the very top of the list, we have EU primary law. We have a number of decisions of the European Court of Justice, as it then was called, of paramount importance, which basically address the existence, the recognition of a company's existence in other member states. Now, these primary law considerations only apply, obviously, to member states. It does not tell us anything about a company from China, from Turkey, from Russia, Australia, and so forth. Now, the same holds true in large measure for EU secondary law. We have a long list of directives, and indeed, these directives that either existed or were contemplated are one of the reasons why there is a carve-out for company law in the Rome regulations. We may have regulations, and we have, last but not least, we have procedural law, particularly Article 24 of the Brussels regulation makes sure that many cases are decided in the country where the company has its seat, which, by the way, is determined under domestic private international law. And if you have such a scenario, you avoid in large measure that you have to resort to international private law. But in many cases, you still have domestic international private law. And I have tried to portray, to depict this on the next slide. I'm not very good in PowerPoint, I have to add. So you have a nucleus, a core of internal affairs, which are governed by whatever law in the European Union, generally the law of the country where the company was founded, where it was set up. And then you have an area of intersection, of interfaces with the outside world. And here you may have, and I start from the top, you may have EU primary law, you may have regulations, you have a long list of directives, and you have a large part of domestic international private law. Now, the next slide, and I apologize for the small print, but I did this on purpose. I'll tell you in a few moments. The next slide shows the decision of my court, which submitted questions to the European Court of Justice. I'm not going to read them out in full. What I want to show is we asked a long list of questions, and the answer was very short, And a number of, by the way, for the benefit of the audience, I have also added pictures of our respective courts, and it's up to you which you prefer. I like the ambience of a 19th century building, by the way. So we asked a long list of questions, including, does EU primary law influence the applicable law when we talk about companies? Because the very decision we recognize a company, the way it was set up, may also have consequences for a long list of other questions. Now, unfortunately, all this was not really answered by the European Court of Justice. So a long list of questions remains. And that takes me to my last slide, or actually, second to last slide. I do have one where I thank the audience for their attention. But I think you all know, and probably you knew that before signing up to this afternoon's event, international company law is a matter of extreme practical relevance. We are seeing more and more cases involving company law which transcend, which go beyond national borders. And my own experience from a small, obviously landlocked country clearly supports this. We have more and more cases with some international dimension to them. And from the small graphical illustration I tried in my presentation, I think it became also quite plain there are a number of theoretical and also, I should add, practical difficulties when we address international private law. And I think this already makes clear there is need for further research. Now, without further ado, I just want to thank you for your attention, and I give the floor, if I may use the term in a purely electronic environment, to the next speaker. Chris.
Yes, thank you, President Kodek. Thank you so much. With your kind permission, I will directly tie into your penultimate slide and the need for further research, because the practical need that Professor Kodek just outlined, the practical need in order to determine in a legally certain and reliable way which laws are applicable to a given company, be it from a EU member state of origin, be it from a third state of origin. This practical need, in fact, is what our project is addressing. Our starting point has to be that what also Georg Kodek kindly outlined, that there has been somewhat a piecemeal approach of the European Union to this eternally debated question of conflict of laws for companies. Piecemeal in the sense that we will find, especially in secondary law, but also in ECJ or CJEU adjudication case law, we will find a lot of particular part solutions to the questions, but we will not find a fully fledged, systematically coherent solution offered by EU law. And this is regrettable in many ways, one being the practical relevance of the question, the second being that, as evidenced by the sources we just cited, EU law, materially speaking, has already reached a rather far-reaching consensus on most, or at least many aspects of the law applicable to foreign companies. However, this consensus yet has to be worked out and put into operational legal terms. And this is what the project strives to achieve. Now, what the project does, as outlined in the materials you can download from the ELI website, is we are trying to take one rather new methodological route. And this is what we call the gray acquis. Georg Kodek has rightly pointed out how unsatisfying answers by the ECJ sometimes can be. You have a lot of questions, and then ECJ comes back with some kind of laconic two-liner. Now, this may be part of the story why so many questions on EU law in general, but specifically when it comes to the law applicable to companies, are really decided upon implicitly. That is, we will find national member state courts that either do not refer questions to the European Court of Justice at all, or that give judgment on cases that henceforth or later on get settled and thereby don't reach the light of European attention, or following the Silphid criteria as laid out by the European Court of Justice, member state courts will deem questions settled to be settled European law without maybe that being the case, or that question at least being debatable. That is why, in order to give a full picture of the actual de facto application of EU law applicable to foreign companies, we want to include this gray acquis communautaire, or this gray acquis unionnaire. That means we want to let that feed into our general assessment of the question. Second hypothesis we have is that we look at certain approaches that have been made in the past to make this kind of, if you want to call it, Rome 5 regulation happen, all of which have failed. And they haven't failed due to lack of intellectual clarity. Especially the recent approach by GEDIP is very convincing, at least in my personal view. But it has been rejected by political reticence. That is, some member states being keen on preserving their sovereignty on certain questions they deem simply vital to their own political sovereignty. And it is this fear to have these sovereign policies be undermined by a Rome 5 regulation that has induced some member states to discard the whole idea in the first place. That is, to have it dead in its tracks from the get-go. Now, what we try to do, and this leads on to the methods we try to apply, we would try to weaken this objection from this political objection by implying and by sort of bringing to bear true private international legal methods to the question. What do I mean by that? For example, when member states are afraid of such a regulation to undermine their national policies, for example, environmental policies or foreign trade policies, co-determination policies, what they implicitly assume is that by the very fact that a foreign company has foreign law applied to it, that is foreign company law applied to it, that member states will be will have that part of the sovereignty taken away as well. Now, one answer by private international theory to this is that you can have a foreign company with foreign law applicable to that company, as is, notably to what Georg Kodek termed internal affairs. But then at the same time, be it through the use of mandatory norms, be it through characterizing questions as being insolvency law, as being maybe law of torts, the Rome 2 regulation has been mentioned by Georg Kodek. So by using these private international techniques, you can actually have the cake and eat it. So you can have a foreign company subject to foreign law and at the same time preserve national policies on specific aspects. So what we see here is there is plenty of room for political compromise that can be drafted and administered by private legal theory. And this is why our project strives to to go down that route, and by using national reports in order to acquire that body of gray acquis, having that feed in to the larger spectrum of secondary law, primary law, of CJ EU case law, and hence come up with a restatement of the kind of private international law as regards companies, and to have that restatement as a expression of the totality of the law, if you will, that is already available. That is a meticulously worked out status quo that goes beyond these 8 or 7 decisions everybody knows by the ECJ. So we take that as a starting point and use that as a springboard in order to develop a draft, a new draft for such a Rome 5 regulation. A Rome 5 regulation that will have certain new kind of gadgets built into it. One gadget, for example, being the idea of a framed mandatory norm exception that is not allowing mandatory norms just across the board, unlimited, but rather to sketch out the policies where mandatory norms will be most probable, and by limiting, by kind of channeling and containing this member state margin of appreciation within those very fields. And as I understand, this is one of the topics that Luca Enrique is going to focus on. So I think I'll leave it there, and I'll be happy to answer any questions during our Q&A session. Thank you so much.
Thank you very much. But before we hear Professor Enriquez, we have Jessica Schmidt, Professor Schmidt from Bayreuth. You have the floor.
Oh, thank you very much. First of all, many thanks to the European Law Institute for organizing this webinar. I am honored and delighted to be here. And thank you very much to Christo Mahle for preparing this valuable feasibility study. The first issue the study addresses is the very basic question: is there a need for an EU regulation on conflicts of laws for companies? In my opinion, the answer to this question is very simple and straightforward: yes. In this respect, I'm in full agreement with Christo Mahle and many others. Practitioners and scholars have long called for harmonization of the rules on conflicts of laws for companies in the EU. Originally, the European Commission had envisioned to include such rules in the company law package. But despite urgent appeals from practitioners and scholars and extensive preparatory work, the Commission ultimately refrained from this after all. The impact assessment to the company law package still contained a detailed analysis of options and indicated a clear preference for harmonization on the basis of the incorporation theory, combined with some specific rules pointing to the law of the real seat. But in the end, the Commission decided to not propose a specific legislative act on conflict of laws at this point in time. The Commission asserted that the instances where clarity is most needed, namely specific issues related to the law applicable to limited liability companies in cross-border situations, would be addressed by the new rules on cross-border mergers, divisions, and conversions. But this does not really ring true. As a matter of fact, these rules do not solve the real problem. On the contrary, without harmonized conflict of laws rules, the rules on cross-border operations in the company law package, and now the company law directive, lack a solid fundament and rest on a very shaky ground. To give a very simple and basic example, Article 118 of the Company Law Directive provides that the chapter on cross-border mergers shall apply to mergers of limited liability companies, provided at least 2 of them are governed by laws of different member states. And then Article 121, subsection 1b continues to say that, save as otherwise provided, a company taking part in a cross-border merger shall comply with the provisions and formalities of the national law to which it is subject. But how do you determine by which law a company is governed? The jurisprudence of the ECJ, we all know, Centros, Übersering, Inspire Art, they have already been mentioned. That jurisprudence has already de facto established the home country principle, or EU incorporation theory, with respect to inbound cases. If a company moves its head office to another member state, that member state has to recognize the company as a company incorporated, as a company governed by the law of the member state of incorporation. But this answers only a small part of the question. Which matters actually belong to company law? We all know that drawing the boundaries between company law and insolvency law, or company law and contract law, can be rather tricky. And finally, what about companies from third states? If these questions are answered differently in different member states, the result can be that the very same company will be treated differently in different member states. And the problem is not really limited to cross-border operations within the framework of the Company Law Directive. Far from it. It arises every time a company acts within a member state where it does not have its registered office and its head office. So to sum up, a harmonization is urgently needed.
Thank you very much.
Sorry, I'm not
I was
finished.
surprised actually, because you still have some remaining time.
No, I was not finished.
Okay, sorry for that.
Actually, I wanted to continue with the next question, what regulation should actually look like. Building on early academic work, the feasibility study proposes that the general rule should be the incorporation principle. This seems evidently sensible, and I have also already advocated for this in my study for the European Parliament in 2016. Codifying the incorporation principle is actually the logical continuation of the jurisprudence of the ECJ and Centros, Übersering, and Inspire Art. Moreover, the incorporation theory has two important advantages. On the one hand, the registered office as the connecting factor can be determined easily. And on the other hand, it provides founders with the freedom to choose the applicable law via their choice of the place of incorporation. As the feasibility study emphasizes, it will also be of paramount importance to provide certainty with respect to the scope of company law. I fully agree that it would be essential to include a comprehensive catalogue of issues belonging to company law, similar to Article 7 of the European Insolvency Regulation or Article 12 of the Rome I Regulation. In this respect, some rather tricky questions will have to be answered, especially with respect to the delineation to insolvency law, which has also already been mentioned. But finally, generating legal security in this controversial battlefield would be a price worth fighting for. Another neuralgic issue will be co-determination, especially from the German point of view. Given the political sensitivities in this respect, it might well be advisable to include a special rule on the law applicable to co-determination in order to placate any fears of co-determination being undermined. Another crucial question is how to deal with non-EU member states. The feasibility study proposes a universal application of the new regulation. This not only follows the established tradition in the EU conflicts of laws realm, but is evidently sensible. After all, the problem which law to apply is not limited to EU companies, but arises just the same in case of companies from third states. Moreover, a kind of split system would lead to a number of new problems. It is often argued that applying the same conflict of laws rules to non-EU companies is not appropriate because they are not subject to the EU harmonization measures. The feasibility study also contemplates to apply another connecting factor to them, for example, COMI or real seat. However, in my opinion, the fact that non-EU companies are not subject to the EU harmonization rules does not justify to treat them differently in terms of the basic connecting factor. Moreover, at least where the EU or member states are party to international treaties granting national treatment to companies from non-EU states, it would not be possible to apply different rules to such companies. Hence, in my opinion, the incorporation principle should also apply to non-EU companies. The legitimate interests of creditors, minority shareholders, and the general public can be catered for by special rules on the applicable law to certain issues, overriding mandatory provisions, or, in the last resort, the auto public exception. The feasibility study proposes a three-step work program. The first step is to set up an open access database of case law from EU member states pertaining to conflicts of laws. This, in and of itself, would be a major achievement. Unfortunately, many courts and scholars in the various member states seem to live and argue in some kind of their own national bubble, and real interaction and active exchange is few and far between. A comprehensive open access database would be a major step towards breaking down such barriers and stimulating a really European discussion. ELI would be ideally placed to host such a database. Yet, it should also be noted that the problem just described is not unique to conflict of laws for companies, but a much more general problem. Ideally, there should be a general database with all EU and member state case law concerning EU law, and that might be some further project for ELI in the future. Secondly, the feasibility study proposes to produce a restatement on EU conflicts of laws for companies. Such restatements have a long tradition and play an important role in the United States. In the context of EU conflicts of laws for companies, such a restatement could indeed make the status quo much more accessible and transparent. However, I fear that drawing up such a restatement will require a tremendous amount of work. Moreover, I suspect that with respect to many questions, it will be quite hard to come up with a clear rule which is accepted in all member states. This already starts with the very basic definitions. The draft restatement, for example, aims to establish a definition of the term shareholder. But as those familiar with the history of the Shareholder Rights Directive will remember, reaching consensus on a definition of this term proved to be impossible, leading to the entire Shareholder Rights Directive also resting on quite shaky ground due to the lack of the definition of this very basic term shareholder. Then again, if the restatement ultimately consisted to a large part of this issue is controversial, it may make the need for harmonization all the more clear. Be that as it may, the ultimate and essential goal is the elaboration of a draft regulation. A clear and concise draft regulation based on thorough and well-funded research and endorsed by the European Law Institute may be the decisive impulse needed to finally push the project of harmonization of the conflict of laws rules for companies across the finish line. Thank you for your attention.
Thank you very much. And again, I apologize for interrupting you before. Now, the next speaker is Professor Luca Enriquez from the University of Oxford. Now, I'm not sure the nice weather depicted on his screen accurately shows us weather conditions as they are in the United Kingdom. Professor Enriquez, the floor is yours.
Thank you very much, Georg. I will leave you in doubt about that. That's the best I can do with not much hope. But first of all, let me also thank the European Law Institute and Georg and Chris Tomale for having me here today and for having the chance to reflect upon a thought-provoking and brief study that was also appreciated. I will comment on two issues. Focuses more on the idea of drafting new legislation than on the idea of a restatement. And the two areas are the 2 points are what is the goal of positive harmonization of conflict of law rules, and second, what should be the mandatory requirements that are recognized as admissible in the regulation. So the study, if I haven't missed anything, identifies legal certainty as the main goal of the initiative, of the legislation. I would argue that this is an insufficient goal because it tells us nothing as to what the criteria should be, what the rules should be for companies, and therefore we need something more. At the very least, I think we should ask ourselves whether, and the answers are obvious, but the main, the usual suspects here are corporate mobility for freedom of establishment and the protection of members and others from the treaty, of course. But the problem is that corporate mobility has two meanings, basically. One is the traditional meaning of freedom for individuals and organizations to actually effectively establishing a business throughout in another member state. But there is a second one, which is the centros meaning of freedom of establishment in this area, which is basically the freedom to exercise, to make use of regulatory arbitrage opportunities by incorporating in incorporation doctrine countries and making a U-turn to the place where the business is run. So for sure, the new legislation should think about what combination of these three goals should be taken: legal certainty, corporate mobility, and protection of members and others. But at the same time, it should make a choice about corporate mobility. I have seen, I was observed that the idea is to choose the incorporation theory as the criterion. And while that is, of course, justified for a restatement, I would argue that some more thought should be given to whether that is the best solution for new legislation, because that includes allowing for pure regulatory arbitrage, of course, with all the limits that other parts of the regulation would set. But I wonder more fundamentally whether this choice is consistent with the current political climate within the European Union. Perhaps centros is an anachronistic anomaly in the case law in the area of also freedom of establishment, but for sure on the four freedoms. And so if the zeitgeist has changed and the political case for the incorporation theory in this broader central style sense is today much weaker than 20, 21 years ago, perhaps we should think more about it. So I will also note that sanctioning the incorporation theory into EU law is not just about permitting almost unfettered or easier use of regulatory arbitrage opportunities, but it's also about individual countries' preferences, about the conditions for lending, providing one's own corporate law rules to non-domestic firms. So countries which opt for the real estate doctrine actually tell non-domestic businesses that if they want to use their company laws, they have to have a real seat there, whatever that means. So is there a reason for imposing the incorporation doctrines also to those countries which, for whatever reason, be it just tradition or something more, are more picky, so to speak, in allowing other countries' businesses to choose their own jurisdiction? So I wonder whether legal certainty and the need for uniformity are sufficient to also impose this kind of constraint on individual member states' choices in the area of corporate law. So that's my first point. The second point is about mandatory requirements. I of course appreciate the idea that there should be limits and that it is a good idea to identify these limits, even though I'm skeptical that it will be possible to have a regulation without some general final clause that allows for some more scope for mandatory requirements to be inserted ad hoc by states or courts in the individual cases. But this is a a very important aspect of this exercise, because the incorporation doctrine has been chosen as the criterion. That makes a mandatory requirement more central to the endeavor, of course. So clearly, harmonization of substantive law is insufficient to appease member states into accepting a uniform set of conflict of law rules with little scope for mandatory requirements. But there are some, and there are some areas where this is not an issue. So we know that there are not many cases that are brought up on whether this is possible, but there are still some areas where intuitively or from experience we know that member states are sensitive. In the years after Centros, you would have said that the legal capital was one of these for private companies, of course. That's no longer the case, but perhaps capital maintenance is an area. And in fact, some member states do impose capital maintenance rules for private limited companies as mandatory requirements. Second area, co-determination, already mentioned, and I won't say much more on that. It's pretty obvious that this has to be dealt with specifically. And I would add also rules relating to companies in the twilight zone, so in the vicinity of insolvency. And I will say a couple of words on this. So capital maintenance rules, the question there is whether they are themselves consistent with the treaty. I would wonder whether they pass the Gebhardt test before they can be inserted as a mandatory requirement, and whether they should be for all companies or just pseudo-foreign companies will also be an important question. Twilight zone rules are already dealt with, at least in part, by the regulation on insolvency proceedings and the related case law. So the question is whether there is a need for EU corporate law to deal with them, and whether that's the right place. So Rome 5 would be the right place, or rather, if there are issues, are we sure that they shouldn't be clarified in the regulation on insolvency proceedings? That's a question mark, which will depend, of course, on complementarities between the various instruments and so on. Finally, the draft report itself identifies other areas very, very quickly that may deserve mention and may allow for the use of mandatory requirements. They are foreign trade, national securities, and, passingly for me, other rules of corporate governance. So this, again, I don't know what you have in mind by that, if co-determination is dealt with elsewhere. And I would just send you a note of caution about allowing states to impose their own mandatory requirements in the area of corporate governance. And here I go back to where I started. So you need to tread carefully here, because if you are generous with allowing for mandatory requirements to apply in the area of corporate law, you may end up with less legal certainty, not more, about how a company operating in multiple jurisdictions will be regulated. That's all. Thank you very much for your attention.
Thank you very much. We already have a number of questions. I promise that we use our best efforts, to use a technical term, in trying to answer these questions, but due to the large number of participants, it may not be possible. The first question I would like to read out, and I would ask maybe Professor Schmidt to answer it. The question is, and I'm shortening a little bit, is international commercial arbitration an alternative to an EU conflict of laws for companies?
First of all, thank you for this interesting question. There's always the question, could we find a route out of the problem via arbitration? In my opinion, it will be interesting to think about using arbitration, but I don't think that international commercial arbitration will solve the problem because, first of all, you would have to get specialized panels for that. And then the big drawback that I see is that the decisions would probably not be made public, and so we would not be able to build up a coherent body of case law. So I think that from a harmonization perspective, this would definitely not be an ideal solution.
Thank you. We then have a question which I think can best be answered by Chris, Professor Tomale. I think he addressed this issue before, but maybe you can come up with some supplemental answer. How does the ELI work on this matter relate to or differ from the TDIP or ETPIL proposal for a regulation on the law applicable to companies?
Yes, so thank you for that question as well. So one of the big shortcomings of these former proposals, and that would include the GEDIP proposal, but others before, for example, by Sonnenberger, is that they fail to clarify notably the scope of company law for the sake of determining the actual impact of such a regulation. So formal discussions have really just been clustering around the connecting factor, as we call it in private international law. That is whether we use real seat, incorporation, center of main interest, or all sorts of faceted versions of them, while the actual scope, that is which questions exactly qualify as company law, has been left unanswered. And in the GEDIP proposal, they leave that very much out in the open, but they make an interesting footnote. One footnote addressing the question of debt equity swaps, which, whole scale have to be, should be treated according to GEDIP as insolvency law. I like that assessment. I also think that indeed, as a restructuring instrument, asks for some kind of, how should I say, some kind of homomorph, clarity. It should really be the applicable insolvency law that determines the whole question of debt equity swaps, even if that does include consensus, say, by shareholders. But of course, questions don't stop there. And this is actually what we would like to focus on our work on. As Jessica kindly pointed out, pretty close, pretty similar to what Article 7 does to the insolvency regulation, or Article 12 in the Rome 1 regulation. So it's really a lot about the scope, and then also this whole mandatory norm business that Luca talked about.
Thank you. The next question for Luca, Professor Luca Enriquez. Shall the envisaged Rome 5 regulation include provisions on the scope of application, that is defining what shall be governed by the law determined as applicable to the company in question?
So the question is whether it should, because I am not involved in the project, and therefore I cannot answer for from an internal perspective. But if the question is can be answered with the should instead of shall, I would definitely answer yes, because otherwise you would give very little legal certainty to the users of this piece of legislation. And I guess the answer is that it shall too, looking at Chris's reaction.
Thank you indeed. The question was shall, and probably making a Freudian mistake. I said should when I read the question out to you. Okay, thank you. Now I have another question, and I would like to put this to Professor Schmidt again, but maybe Chris, you would like to step in after that. The choice in favor of a universal application of such a Rome 5 regulation might face headwind by those member states, the courts of which decided against using the incorporation principle vis-à-vis non-EU companies.
Well, thank you for raising this very important and interesting issue again. I think that assessment is probably really correct, especially like coming from Germany, we have exactly that situation that our federal Supreme Court has said that vis-a-vis third countries, we use the real seat principle. We still use the real seat principle. And that leaves us in this limbo where every time we have to check, okay, this is a third state. Do we have a special international treaty with that third state? Is there any reason why we might nevertheless have to apply the incorporation principle? And this is really difficult and tricky. And as I tried to point out in my intervention earlier, I don't think that it's really necessary to have another connecting factor. I think if you apply overriding mandatory norms, and in the very worst case, the auto-oblique rule, you can protect sufficiently the legitimate interests of creditors, minority shareholders, and the general public without having to have two different general rules on how what to use as a connecting factor. And I think it would be necessary to in the political process, it would be valuable and necessary to show, well, what issues could actually arise and can we deal with them under the scope of the incorporation principle by using these other instruments in the regulation and still come up with results we are all happy with. And I think that would be possible, and I think that the ELI project could make a significant contribution in this respect.
Chris, you wish to add to this?
Yes, so first, I fully concur with Jessica and what Jessica said. I would like to add two small points. One being that my recent research shows that the apparent subscription of given states to a real seat doctrine sometimes at closer inspection reveals not to be that wholehearted as it does at first sight. So for example, I'm aware of some states that officially apply real seat doctrine, but then, for example, have their advocates on a daily basis manage British Virgin Islands companies without any bigger problem. That is, courts treating them as being legal subjects and whatnot. And in history of for example, the Italian Republic, because we're having this seminar in Vienna now, virtually speaking, but still we do. So when, for example, Trieste fell back to Italy after the First World War, Italy had no problem in recognizing that companies established in Trieste, according to the Austrian closed corporation code, were able to be used no matter where their real seat was in the whole of the Italian Republic. So what I'm saying is that at a close inspection of that gray acquis, people will be surprised what comes out of that. So alleged real seat states will show to have a much more nuanced stance. And just to clarify, because Luca brought that up, when we get to what Jessica rightly pointed out, to these more concrete mandatory norm questions, what I meant with corporate governance, I was trying to catch rules, for example, these affirmative action rules we see in many member states. For example, when it comes to supervisory boards and gender representation, those supervisory boards, there are at this moment ongoing discussions as to how to qualify them. I feel as if the majority were leaning towards considering these rules to be beyond arbitrageability, hence kind of, putting them into the mandatory norm pigeonhole. I just didn't want to be presumptuous as to exclude these opinions offhand. But I'm by no means suggesting a fully fledged, mandatory norm accessibility of corporate governance, because large parts of corporate governance really get to what Georg Kodek termed internal affairs, if you will, the absolute nucleus of what company law is. So that point is very well taken.
Thank you. Now, one of our participants kindly shared with us the text of the GEDI proposal on Article 5 on the scope of the regulation, and you find this if you hit the Q&A button on your screen. I'm not going, for reasons of time, I'm not going to read it out aloud. Now, it seems we have managed two things. First, we have arrived at the end of the allotted time, but more importantly, it seems we have answered or at least addressed and discussed all the questions that have been put to us. So now it comes to concluding this afternoon's seminar, and in doing so, I have to thank all who contributed to the success of this afternoon. I certainly tremendously enjoyed this afternoon's session. I have met most of my co-panelists before, but not all of them. So first of all, a big thank you to all our speakers, all our panelists. Thank you also to the support team of ELI in the background. You can't see them because they turned off out of courtesy and kindness the video, but they are there and supporting and doing whatever and addressing whatever needs may arise. And finally, perhaps most importantly, thank you to all of our participants, and I hope we managed certainly to portray the feasibility study and the kind of research that's being undertaken by the ELI. And for those of you who are less familiar with the topic, maybe to create a new area of interest and a new field of research. And that also clearly would be most welcome. Now, once again, thank you to all of you. Thank you for joining us this afternoon. And even though we are 1 or 2 minutes early, it's too short to address maybe another question. So I think you're all eager to go off to your weekend. So have a nice weekend. And once again, thank you and goodbye.
Thank you very much.